Hello and welcome to our workplace checkup for small businesses. This is the last in our series of our small business webinar series, and happy to be here today to give you some tips to help you provide a workplace that is safe, healthy and compliant with the latest developments in employment law, which we will go through. So my name's Kylie. I'm a lawyer here at the Working Women's Centre. And first of all, I'd just like to acknowledge that today we meet on the lands of the Kaurna people. We acknowledge them as custodians of the Adelaide region, and we respect their spiritual and cultural relationship with their country. We pay our respects to their elders past and present, and extend that respect to all Aboriginal and Torres Strait Islander peoples today. So the Working Women's Centre, we are a non-government organisation. We're a not-for-profit. We're funded to give free and confidential advice to women and vulnerable workers who aren't members of a union. But we're also funded to give small business employers some education about federal workplace laws like we've been doing in this series. So we're funded by the state and federal governments, and as well as SA unions as well, and some other grants that we receive. We have the legal team, which I am part of. There's how many? 4 or 5 lawyers who work for us. We also have an advocacy arm who research, lobby, and do project work to help resolve some of the systemic issues that the lawyers see when we're advising women and vulnerable workers. And we also have an education arm. So part of it is giving these free community legal education sessions, but we also conduct fee-for-service training to employers about workplace rights and obligations. So if you're interested in targeted and specific training for your employees or yourself, or you'd like your policies reviewed, please do contact us and we can discuss our training portfolio with you and adapt training to suit your needs. So without any further ado, let's get into it. This is just a summary of the kind of cases we see at the centre. So employment conditions and dismissals and redundancies are quite a big portion of the pie there. Also discrimination and workplace harassment and bullying, as well as workers' compensation. So what I've put together today is kind of addressing those most popular issues that we see at the centre and trying to give you some information so hopefully that we can prevent those issues occurring, which is obviously best for your workers and also best for you as a business owner. So today we're going to be looking at your obligations as an employer under legislation. We'll be looking at awards and employment contracts, new changes to the laws, and framing that in workplace equity and respect. So really the idea is, I guess, if you've got a safe and healthy workplace in which you have workplace equity and respect, hopefully that will nip any other problems in the bud. So it's really important to think about the culture of your business as we're going through the presentation today. But if things do go wrong, we'll be looking at fair supervision and disciplinary processes, as well as fair dismissal and redundancy processes. So we're relating all of these things back to your obligations under the Fair Work Act and other federal and state discrimination laws. So your obligations as an employer arise from different pieces of law. There's the National Employment Standards that set the national minimum wage and make up the minimum entitlements for all employees in Australia, no matter what industry or type of work you do. There's also enterprise agreements, which are agreements between your workers and yourself, the business owners, setting out conditions of employment. There's also modern awards. So there's many different awards that are set by the Fair Work Commission, and they contain minimum entitlements and conditions for workers in those particular relevant industries. So there's quite a number of different awards for different kinds of industries and different kind of jobs in those industries. So common ones might be the Clerks Award or the Restaurant Award, or even the Dry Cleaning and Laundry Award. There's all sorts of awards, and we'll go into a little bit later about how you can find the relevant award. Employment contracts, which are individual contracts between you and your workers, which have to be better than the workers' entitlements under the award and the National Employment Standards. And of course, then there's the legislation that underpins those things, being the Fair Work Act and state legislation as well, like the Long Service Leave Act and the Work Health and Safety Acts. So again, any award, contract or enterprise agreement can't provide for conditions that are less than the national minimum wage or the national employment standards. So it's really important to be aware that no matter what you agree with your workers, you really at least have to pay them and give them the conditions that they deserve under the national employment standards. So those national employment standards, yeah, they're available on the Fair Work Ombudsman site. There's 11 of them, and we'll go through them quickly here. So they relate to the maximum weekly hours for your employees, requests for flexible working arrangements, the employee's right to request a flexible working arrangement, that is, the employee's right to request to convert from a casual employee to a permanent employee, parental leave and related entitlements, annual leave, personal and carers leave and compassionate leave, whether paid or unpaid, depending on the type of work, as well as family and domestic violence leave. So we'll touch on that a bit later, but there's been changes there as well. Community service leave, long service leave, public holidays, and notice of termination and redundancy pay. And one of the lesser known ones is that every worker upon the commencement of their employment should receive a Fair Work information statement and a casual employment information statement. So not many employees that we come across are aware of this obligation, but the first day of your employee's start date of their employment, you do need to give them a copy of those statements to make sure that they're aware of their rights and that you are as well. So when we're talking about awards, as I mentioned, they set out an employee's minimum pay rate and other entitlements, as well as things like penalty rates and allowances. So awards are available on the Fair Work Ombudsman site. You can use the pay calculator on the site to help you figure out which award is appropriate for your employees. So you can type in their job title, type in the industry, and that will pop up with the award that's relevant. And from there, you can look at different levels of the award. So for instance, if we're thinking about someone who's working in hospitality, someone who is, say, collecting glasses in a pub, they're going to most likely be at, say, level 1 of the award, whereas someone who is managing the pub or managing shifts of workers, opening and closing the shop, handling cash, that kind of thing, will be entitled to a much higher level of the award and therefore a higher rate of pay. So awards have, on the Fair Government Ombudsman site there's also pay guides and helpful summaries of common entitlements of the awards as well. So it's a really good idea to just every now and then go back and have a look at the awards that are applicable to your employees and make sure that you're upholding your obligations under the award. So there have been some new changes to the law recently, and I just wanted to touch on those up front. So there's new legislation that's been implemented, which has come around from the Respect at Work report, which the Human Rights Commission released in 2021. So the Respect at Work report found that it was based on sexual harassment in the workplace and looking at recommendations to help prevent this widespread issue. So one of the things that has been proposed is that there will be a positive duty on employers to take a reasonable and proportionate measure to eliminate unlawful sex discrimination, including sexual harassment, as far as possible. So that means really that if you're really going to have to have a very close look at your workplace to make sure that you are actively preventing sexual harassment, it's just not going to be good enough anymore to deal with a problem once it occurs. You're really going to have to show that you've thought about it and you've prevented your workers from that risk. There's also going to be a new offence of subjecting a person to a hostile workplace environment on the grounds of sex. So that's recognising that some workplaces it might not be any one particular employee saying any particular thing, but overall the work culture is so toxic that the overall culture is actually creating a hostile workplace for someone on the grounds of sex. So I guess a very typical example might be perhaps on a work site where it's a very male dominated industry and it's had a real historical culture of being dominated by men. Those kind of in-ground cultures are the things that I think employers are really going to have to look at and make sure that the culture itself is not hostile to a particular worker. So these are pretty big changes. The 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 bill passed Parliament on the 28th of November, and it's expecting royal assent very soon. So these laws aren't in effect straight away, but they are coming in extremely shortly. So as I said, I think it's a really good idea to think about what you're doing in terms of preventing sexual harassment and making sure that you've got plans in place to review. So there's also been changes to the Fair Work Act. So these acts received royal assent on the 6th of December and come into effect on the 6th of June 2023, or an earlier date in case of these bargaining changes. So I just really wanted to highlight these. It's a bit much to go into today, but there's going to be changes to the bargaining framework, which are aimed at making it more accessible and attractive for both employees and employers to bargain and create those enterprise agreements. So yeah, it's recognizing that it doesn't often happen in small businesses, but the Fair Work Commission is going to proactively assist small businesses to try and negotiate these agreements with their employees. So I suggest you check out the Fair Work Ombudsman site for more information about that if you're interested. An employee's right to request a flexible working arrangement is also going to be strengthened. So if currently you can refuse a request to work flexibly on reasonable business grounds, but the employee will have the right to go to the Fair Work Commission to dispute that refusal. So that means it just gives the employee a bit more power to debate whether or not it's reasonable. But in good news for small businesses, one of the factors that the Fair Work Commission will still take into account is that the size of a business is still a relevant factor for the refusal. So it will still be balanced looking at, what is actually reasonable in terms of your actual business. So moving on to workplace equity and respect. So like I mentioned at the beginning, really this is the foundation of your workplace, your culture, and hopefully keeping your staff happy and healthy and keeping your business out of any trouble. So when we're talking about this, we're talking about upholding your obligations under the Fair Work Act, discrimination laws, and as well as occupational health and safety laws. So you've got the fundamental obligation to provide a safe workplace and an equal and respectful workplace. As an employer, you do have the primary duty of care to your workers to keep them safe, and you need to do what is reasonably practicable to ensure that your workers are ensure their health and safety. So obviously workers as well have a duty of care to take care of their own health and safety, so that they can't negatively affect the health and safety of others and must comply with any policies and procedures and instructions that you put in place. But obviously it's up to you to make sure that there are those policies and procedures in the first place to keep your workers safe. So this is just, again, I'm sure in each of your separate industries, you will have different risks and different ways of assessing those risks, but a very high level summary would be to have a look at your workplace and identify any potential hazards. Make sure that you have appropriate controls in place and document them, communicate them, review them regularly, and most importantly, continuously consult with your employees. So we get a lot of calls from employees where, employees know that there's some kind of workplace policy somewhere about something, but because it's not talked about enough, people don't really know where it is, how to access it, or how to apply it. So it's really important to review your policies regularly and communicate to your staff exactly where they are and how to use them. So ensure that your workers have appropriate training, know how to report issues and complaints, and have connections with their colleagues as well. That's most relevant, I suppose, in industries where you might be sending out your workers to individual jobs. So it's a good idea to try and develop a team cohesion to make sure that any issues and problems are identified and shared and fixed amongst the group. I wanted to touch on the idea of psychological safety as well as physical safety. I think we are most commonly think of safety at work as in a safe physical environment free from risks that would cause physical injuries, but psychological injuries occur as well. So we're talking about mental health effects like depression, anxiety, PTSD, the whole range of things that can happen when someone has experienced, say, bullying or a traumatic incident at work. So we do actually run in-depth training sessions on bystander action and how to address violence, especially family domestic violence in your workplace. But really, I just wanted to set the scene by saying that you again, you're in charge of setting the culture for your business, and you need to make sure that that culture is safe. So fundamental beliefs are important about treating people equally and with respect, and you demonstrating that as the leader of your business, it is really important. Secondly, if you see violence in your workplace, it does become your business. So I actually do have another webinar which you can access on our website about family and domestic violence. There's new laws that have come in, meaning that your employees actually have an entitlement to unpaid leave if they are suffering from domestic and family violence. So that webinar does give you some more tips in terms of how to about those obligations to give the leave, but as well, how to handle a disclosure if an employee comes to you saying that they have been suffering from family and domestic violence. But I guess the fundamental tip right here is that if something comes into your work, like an employee brings a problem to you, or you witness something in the workplace which is violent or problematic, it does become your business. It is connected with then the employee's workplace, and it's important that you take action and take it seriously. So bystander action, again, we do run a whole in-depth training session on this, but really it's the idea that if you encourage and support your workers to speak up and know what is appropriate or not appropriate in the workplace, that not only discourages the perpetrator, it also supports the victim, and it can help improve your culture. So a bystander can either stand up in the moment and say, "Oh, look, I really don't think that joke's funny," or they can report it, say by reporting the issue to you. So once again, if you're interested in more on that topic, please contact us and we're happy to discuss training with you. Right, workplace bullying, we get a lot of calls about this at the centre. So I wanted to touch on first about what workplace bullying is. And this is really leading on, I guess, we've talked about culture and setting a good foundation, a good healthy culture. But if you don't have a healthy culture, workplace bullying can happen. So let's have a chat about what to do if workplace bullying occurs. So workplace bullying is when a group or a person repeatedly acts unreasonably towards one person or a group of workers, and that behaviour creates a risk to their health and safety. So it's really behaviour that threatens, intimidates, or humiliates them, and is so severe that it's creating a risk to that person's health or safety. So workplace bullying is not it's not reasonable management action. So sometimes we get calls where someone's had a disagreement with their boss at work, or they're in the middle of a disciplinary proceeding. As long as that interaction is done in a reasonable way, that's transparent, measurable, and directed at the performance of the worker and not attacking them individually, that's not bullying. So difference of opinion, which don't lead to persistent unreasonable behavior and not bullying behavior. So very fundamentally, bullying is something that's repeated, unreasonable, and creates a risk. Workplace bullying is not something that's fair and reasonable in terms of management or differences of opinion. We just have some examples here of what is bullying behavior. So it might be yelling, insulting or threatening offensive language, being singled out or excluded or isolated, displaying material that's degrading or offensive, ongoing attempts to undermine a worker or their work performance. So setting unrealistic goals or deadlines. So making sure that the targets you're asking of your employee are reasonable and communicated in a reasonable way. Another factor might be having reasonable requests for leave or training opportunities denied, behavior or language that belittles, degrades, or humiliates a worker, especially in front of others. So it's a whole range, and there's no strict criteria as long as it falls within that repeated, targeted, and creating a risk to health and safety. So if you receive a complaint or disclosure from staff, what do you do? The list there are, first of all, take it seriously and act properly. Don't put it in your drawer and see how it goes. It's important that the worker knows that they're supported to make a complaint and that you are taking it seriously. Keep it confidential and ensure a fair process. So it can be hard, especially in a small business, to keep these kind of things confidential. And often with bullying, I think, but often the workplace generally is aware that bullying is happening. But as much as you can, try and ensure a fair process. Be conscious of the language you're using and try and support both the perpetrator and the person reporting the bullying as well, until you've done an investigation and figured out the outcome. Be transparent, keep good records. So make sure that you keep a written record of what you've done, so that just in case there is a claim later down the track, you've got that all well documented about what you did to stop that risk to that worker. And make sure that you follow up with the worker who's reported the bullying as well. So when we're talking about an investigation process, I thought we could go a bit more into that. So again, timeliness is really important, and independence. Again, in a small business, it can be hard to be properly independent and have an objective view of the facts. So consider hiring a third party to conduct the investigation, or at least be as objective as you can with all the documentation that you can. If you need to separate the employees while you're investigating, and stand the employee down with pay whilst the investigation is going underway. And when I say that, I mean the employee that is accused of the bullying, not the employee that made the complaint, because that could be a general protections claim, which we'll go into a little bit later. Keep the workers informed about what's happening. And in terms of the worker who's been accused, it's really important that you give them full particulars of the allegations against them and give them a fair chance to respond. So I suggest you write it all down in a letter and give them, a good week or more to properly respond to that in writing, have the opportunity to get advice if they need it. If they request more time to get advice, I suggest it would be reasonable to do that as well. It all depends on the situation, of course, but you do need to give them at least what you can defend as a fair chance to respond. And once you have their response, you need to genuinely take it into account. So it's no good if you've already made up your mind. You do need to reasonably and fairly look at what they've responded with, and then decide on a reasonable and appropriate outcome. And again, make sure you're documenting all of those steps as well. Keep notes of the meeting, and make sure that you're doing it properly. So a bit more information about a meeting. So if you need to schedule a disciplinary meeting, again, make sure that you've given specific details of the allegations in writing, that's enough that the employee can identify exactly what occasion you're talking about, and so that they can properly defend themselves. It is reasonable to direct an employee to attend the meeting, but you should give enough notice. It should be within their working hours, and it's a good idea to offer a support person to the worker as well, so that they have someone there to help them perhaps take notes. They're not there to talk on behalf of the employee, but just someone independent there who can help and assist the worker, because obviously it's usually quite distressing for the worker having to defend themselves in a disciplinary meeting. So it's just helping manage the risk of that worker being affected by the meeting. It's all part of a fair and reasonable process. So during the meeting, make sure that you stick to the allegations already raised. It wouldn't be appropriate to bring up another occasion that you haven't already warned the employee that you'll be discussing, because they won't have had the chance to think about it and defend themselves properly. So you can imagine, the employee will feel quite attacked if they're suddenly bombarded with other things that they've allegedly done wrong, and it's very hard for the employee to give a fair and balanced response if they haven't had that time to think about it and to prepare a response. If your employee is becoming overwhelmed or emotional, please do allow them a break or reconvene on another day. And just generally try to support the employee as best you can. Like I said, have the support person and try to, it's a difficult process for everyone, yourself included, conducting those meetings, but just, try to do it as calmly and reasonably as you can. So outcomes, as we've said, you must take the employee's response into consideration. I suggest you follow with a written determination of what you've concluded from the meeting, and what the outcome is. So decide on appropriate consequence. It may be a warning, it may even be termination of their employment, but you need to make sure that it's reasonable and fair. Otherwise, again, you may run into trouble, which we'll get to later. So counselling or performance improvement plan might also be appropriate as well. So again, just make sure that the process is fair and that you have documented everything as well. Performance improvement plan, sorry, just a little bit more on that. So again, like we were talking about before, a performance improvement plan that is in itself unreasonable could be bullying. So it does need to have a clear pathway to improvement. You need to provide training and support for that employee to help them achieve the goals in the plan. So it needs to be clear and defined. Those performance goals need to be very clear and achievable for the employee. Make sure that you have ongoing catch-ups to discuss the employee's progress and give them feedback on their performance. So again, hopefully conducting it in a fair and reasonable way will not lead to any claims against you. But just, again, make sure that your employee feels supported and informed of the process the whole way. So if you haven't been able to manage to keep things on an even keel in your workplace and things go a bit wrong, we're going to look at what claims your employee could have against you if say you dismiss them unfairly, or something happens at work, like they're sexually harassed. So we'll step through these things one by one. So terminating employment, this is a very common thing that we get inquiries about at the Working Women's Centre. Unfair dismissals would have to be one of our most common inquiries. So we'll be looking at what makes a dismissal unfair and what is a fair redundancy process as well. So a dismissal is unfair if the employee has been dismissed from their employment and that dismissal was harsh, unjust, and unreasonable. So it's something that cannot objectively be as fair. There's something around it that's harsh, unjust, or unreasonable. It will also be unfair if it's not a case of genuine redundancy. And really importantly for you all, if you're a small business and you did not follow the small business dismissal code. So a bit more on harsh, unjust, or unreasonable. That means there's a list of factors there that a court would look at to decide whether a dismissal was unfair. So it's relating to whether there was a valid reason for the dismissal related to the employee's capacity or conduct, whether they were notified of that reason and given an opportunity to respond. So that's why I was talking about making sure that if you're doing a disciplinary meeting, you give them adequate chances to respond. If you didn't allow them to have a support person available, if they'd been previously warned that the performance was unsatisfactory. So again, like if you had warned them in the past, it'd be good to have written documents of that so that you can show the Fairer Commission that yes, this is true, that it wasn't their first incident. The size of the business or lack of dedicated HR specialists. So that's really recognizing that small businesses don't have big HR departments with internal counsel, etc., and don't have all those resources to do every process absolutely perfectly. That's why the small business dismissal code is really important, and we'll get to that now. So the small business dismissal code is for businesses that have less than 15 employees. And it sets out principles for you to follow. So you can find this on the Fairer Ombudsman site. And it's like a checklist that you can go through if you need to dismiss an employee, setting out all those kind of factors that we've talked about, like whether there was valid reason, whether you've held a meeting, what you've done. So it's really there to help small businesses in a simple way, have a checklist in front of them where they can know what they have to do and make sure that they've ticked off everything in order to fairly dismiss their employee. So if you can show that you have complied with that code, it is a defense for you against a claim of unfair dismissal. So again, documentation is very important. If you need to dismiss an employee, have that code there, make sure you've followed it. And then if the employee lodges an unfair dismissal claim, you'll be able to say, well, it wasn't unfair, I followed this fair dismissal code. And that will be a really tight defense for you. So yeah, on the Fairer Commission site, sorry, but there's a lot of information there for you as well on the code. So redundancy. I think we all are probably familiar with the idea of redundancy when a business perhaps is going through a structural change or it's closing down, and workers need to be let go for operational reasons, not because they've done something relating to their capacity or conduct. So again, a defense to an unfair dismissal claim would be that it is actually a genuine redundancy. They weren't fired unfairly, but it was actually a redundancy. So a dismissal is not a genuine redundancy if you still need the job to be done by someone else. So you can't make an employee redundant and then hire someone else to do that exact same job. The job itself has to disappear, not the person. Awards and agreements have consultation provisions in them, meaning that if you're thinking about making an employee redundant, you have to let them know and consult with them. So again, important to know which award you're under and which consultation provisions apply, and make sure that you follow those obligations to consult with the employee. Otherwise, it could be an unfair dismissal. And thirdly, it won't be a genuine redundancy if you could have given the employee another job within your business or associated entity. So if you're restructuring and you're losing one position, however, you're creating another position, you need to assess whether the employee you're making redundant has the skills and abilities to do that other position, and genuinely consider that. So even if the new position is less pay, for instance, you still need to present that option to the employee and make sure that you've followed those provisions to consult. So again, a lot more information on this on the Fair Work Commission and Ombudsman sites, but those are kind of factors to think about if you need to make an employee redundant. So General protections. I wanted to mention this because it's a pretty fundamental right that workers have, and it's important that you're aware of the workers' right. So basically, every worker has the right to make a complaint or inquiry about their employment without suffering an adverse action against against them. So a worker has a workplace right if they're entitled to the benefit of a workplace law, um, and yeah, the right to make an inquiry or complaint about employment. So there's other rights that are protected by the Fair Work Act as well, like being a union member, um, having a workplace free from discrimination, and a protection against sham arrangements, like probably a little bit complicated to get into right this minute, but where a situation where a person is employed as an independent contractor, but really in effect they're an employee. So there's a number of what they call general protections covered by that an employee has. And if an employee has those rights and they raise them and you take adverse action against them, they can file this kind of claim in the Fair Work Commission. So an adverse action, it's a negative kind of consequence. So it might be if a worker makes a complaint or say raises an inquiry with you about their employment, like if they're getting paid at the correct rate and you impact them in a negative way, like dismissing them, injuring them in their employment. That's a very kind of legal way of saying making some adjustment to them that negatively affects their employment, altering their position to their detriment, discriminating between one employee and another, like treating someone more favorably, say if they're not a member of a union, refusing to employ a prospective employee or discriminating against a prospective employee on the terms and conditions in the offer of employment. So there's a number of things there, but basically remember it's some kind of negative effect on the employee's employment. So just before we finish off on that, it's important to understand, I guess, to wrap it up, that if an employee comes to you with a complaint or inquiry, you must be very careful not to take any action that could be perceived as negative to them or adversely affects them. Because yes, this claim would be in the Fair Work Commission and they can seek compensation or an order from the Fair Work Commission for reinstatement or other measures. So just keep that in mind. Very, very important. Moving on to discrimination in the workplace. So workplace discrimination occurs when an employer takes, again, an adverse action against an employee or someone who's applying for a job, a prospective employee, on the following attributes of the person. So these are the things that are protected by the law. It's not completely comprehensive, as you'll see, but it includes race, color, sex, sexual orientation, age, disability, marital status, family or carers' responsibilities, like if they need to take care of children or elderly relatives, pregnancy, religion, political opinion, or national extraction or social origin. So if you discriminate against an employee on one of those bases, then they have grounds to file a claim of discrimination. Again, there are also laws protecting against sex discrimination and sexual harassment complaints. So there's different time limits for making those complaints, 24 months in the Human Rights Commission and 12 months in the Equal Opportunity Commission. And those time limits apply from the last act or last in the series of acts. So again, very important to make sure that your workplace culture is safe for workers and that you, again, with these new laws, that you've proactively tried to prevent the harassment from occurring, because you could be vicariously liable for the actions of one of your employees against another employee, for example. So just wanted to kind of give you some ideas about how to start developing a strategy to deal with sexual harassment. And again, if you need further training on this, please contact us to have a chat, and we're happy to provide some fee-for-service training. But really, it's a bit the same as the risk manager process I talked about earlier. Identify people who are at risk of sexual harassment. So think about your employees that may be working late or working alone, or might be particularly vulnerable from their age or lack of experience dealing with customers or something like that. Except that sexual harassment does occur. So it does. We've received so many calls about it from every industry you could think of, pretty much. It does occur, and it does occur in workplaces. So never think that your workplace is immune from it. It can and does occur everywhere. So it's pretty fundamental to accept that it can happen, and therefore you must manage that risk. So once you've identified those hazards, assess the risk and control the risks, and implement workplace policies around those risks. So it might be that you don't allow staff to work alone at night, or you might have a policy where if a worker is locking up after a shift, that someone else helps, walks them to their car after work, or that they can lock the door after a certain hour. Those kind of practical things that can help prevent the risk of harassment occurring. Could also be things like providing training to your staff about how to handle a customer that might be belligerent or acting inappropriately to them. How do they immediately handle that? Where do they go for help? How do they report it to you? If they're feeling physically unsafe, what do they do? Go through all those scenarios with your workers and have a think about it, and make sure that they're supported and informed to know what to do. So yeah, providing that kind of information and training, and report and respond to sexual harassment. So again, make sure that if you receive a report, you treat it seriously and appropriately. So look, we're coming to the end of the session, but I wanted to cover off on some, your plans for the new year. So just summarizing what we've talked about today, and make sure that your workplace is in a fit and healthy place for the brand new year. Review your physical and psychological safety of your workplace. Look at your workplace and assess whether there's any risks there to your staff, whether physical or if there's a danger of harassment or bullying. Check you're paying your employees correctly. Have a look at that award or your enterprise agreement or your contracts. Make sure, if you've got a contract, make sure it's meeting the minimum entitlements under the award. We haven't really gone into underpayments here today, but obviously if you're paying your employees less than what they receive under the award, they could have an underpayment claim against you with penalties. So it's very important that you review the award and make sure that you know what you're supposed to be paying them. Review your policies around bullying and sexual harassment. As we've talked about, there's going to be that new positive duty on you to actively prevent sexual harassment in the workplace. So it's absolutely critical that you can show that you've thought about it and address those risks. And finally, schedule a check-in with your employees. Have a talk to them and see how they're going, and see if they can have identified any risks, or if they have any concerns about their employment. Communication is really so important, both to an employee's sense of well-being and being heard, and knowing that you care and listen to them, but also often they're identifying risks in their daily work that you might not have the visibility to see. So that kind of continual check-in with your employees is also really important, and it's a good idea at the beginning of the year to perhaps think about scheduling those in and making sure you're keeping up with that throughout the year. So yeah, we've got some further training, as I've been mentioning. There's a list there of the kind of packages that we do. So responding to domestic and violent violence in the workplace, defining and handling workplace bullying, preventing and addressing sexual harassment. Those kind of training packages are available. One of our trainers can come out to your workplace and deliver that training to your staff. We can do it online as well if that's better for you. So yeah, give us a call if you'd like to look into how we can assist you in those ways. We also provide fee-for-service consultation on policies. So if you're developing those new policies and you want someone to have a look over them, we're more than happy to do that. So again, contact us and see how we can help. I also just wanted to give a shout out finally to the Ferric Ombudsman website. They have a small business showcase, which has a lot of really excellent and helpful resources that help small businesses find their way again around all these obligations you have under workplace laws. So it's really great. There's lots of videos and fact sheets and quick and simple things for you to have a look at, and pathways for further help if you need as well. So do check it out. And again, it's a good thing to do at the beginning of the year to make sure you're on top of all your obligations. So thank you so much. We will wrap up this webinar today. So please do keep in touch with us on our socials and our website. We will more likely be running these kind of webinars again next year. So do keep an eye out on what's coming up. So thank you so much for attending. I will be sending out a feedback form, so I'd appreciate it if you could fill that out. And once again, please contact us if you've got any questions or inquiries about training. So with that, wishing you a very happy and prosperous 2023. I hope this seminar has been of help, and best of luck. Thanks so much.